agenda. Item number 1, the minutes of the meeting held on the 29th of August have been on tape for half an hour. As you wish, I sound them as a true record. Thank you. Apologies for absence. Emma?
We have apologies from Councillors Christian Hesse, Robert Knowles, Stephen Mulliner and David Round.
Thank you very much. Disclosure of interest. Emma?
None prior to the meeting, but I believe all Havesmere Town Councillors declare a non-pecuniary interest in the applications.
Thank you. Question by members of the public.
None received.
Question from members, Emma?
None received.
Okay. Any relevant updates to government guidance or legislation since the last meeting, Beth?
No, nothing, Chairman.
Okay, and performance against government targets, item page 5.
Thank you, Chairman. So page 5 just shows members the planning services performance on the 2 government targets relating to speed and quality. The figures really just speak for themselves. We are achieving and exceeding those targets. Thank you, Chairman.
Thank you very much indeed. We move on to applications for planning permission. Just find the right piece of paper. Application A1 at WA 2017-1621 Marchants Hill, Tilford Road, Hindhead, GU 26 RF, pages 7 to 90 of the agenda. Proposal is the erection of 4 buildings to provide guest and staff accommodation, erection of classroom building, alterations and extension to the existing reception and kitchen buildings, alterations and extension to existing activity lake, parking, access routes following demolition of the existing accommodation building and associated outbuildings as amplified by drainage plans received. And I turn to Louise Yandel to introduce the application.
Thank you, Chairman. Firstly, I would like to give members a verbal update to the recommendation. In the agenda report, recommendation B on both pages 7 and 24 of your agenda sets out that in the event that the Section 106 agreement is not signed within 1 month, permission will be refused. Whilst the Section 106 is ready for signing, it is recommended that this is amended to 3 months to allow for any delays with the signatories. Thank you. So moving on to the item itself, members will recall in January the Southern Planning Committee resolved to approve this application subject to the signing of a Section 106 agreement to secure highways works and the provision of speed signs. There has been a delay in the signing of the Section 106 agreement due to delays with the London Borough of Kensington and Chelsea, who are the freeholder of the land, and their legal team agreeing the draft Section 106. This was not refused in July, in line with the recommendation, in order to work positively and proactively with the developers on a development which the Council had considered acceptable and to give them time to resolve the issues with the Section 106. Since the time of the previous resolution in January, there have also been a number of other changes in circumstances. The first is that the sweetment judgment was issued. This changed the way that the Council assesses development that is within close proximity to the SPA. As a result, the Council has carried out an appropriate assessment to assess the impact of the proposal on the special protection area. This concludes that the proposal would not have an unacceptable impact on the SPA and has been approved by Natural England. The second change in circumstance is that the Council's local plan was adopted in February. There are no policies in this plan that would alter the conclusions of the committee in January. The third change in circumstance is that the revised MPPF was adopted in July 2018. Again, there is nothing in this document that would alter the original conclusions of the committee. The test for members this evening is therefore whether any of the changes in circumstances that I have outlined warrant reaching a different conclusion. Members are reminded that it would be unreasonable to revisit the conclusions of the original committee where there have been no changes in circumstance. Thank you, Chairman.
Thank you very much, Louise. This item is due for public speaking, so I ask Chris Violet to step forward. Yeah. Have you? Can you get by? Hey, sorry. She's slim, but not that slim. Sorry, Emma.
Okay. Good evening, everyone. Obviously, I'm here to tell you why the local residents oppose the extension of PGL. We made a couple of points. First off, I'd like to say that this is a rerun to us of a meeting held on the 31st of January here, where permission was granted. One point we'd like to raise is that just prior to the vote of the members on the application, there was an extensive comments made by various councillors in favour of PGL's application, which weren't really relevant to the application, but we felt that they were supporting the PGL application, and we had no chance to rebuff those comments, and in the main we found them inaccurate, and we feel that this was part of an injustice towards the opposition. Another point really was that council made a joke of the application. This was very insulting to the objectors, and we would like to make a note of that as well. There are still over 40 objections to this expansion plan, and only 3 in favour. The ones in favour believe it will benefit the local economy. PGL operate a closed camp, which means that none of the guests are allowed out of the village, out of the encampment, so there's no spending in the village, so economic benefit is more or less nil. PGL is not a charity, it's a business. Its aim is to maximise profit. For its shareholders, PGL is currently up for sale. Cox and Kings, who own PGL, has seen their share price drop about 30% over the last year. This is because they are selling off shares and PGL to try and raise capital. PGL are in a dispute in Yorkshire with residents over Newby Wisk Hall. 2 independent accountants have worries over PGL's finances. The council should seek a financial bond from PGL if planning approval is granted. The new owners can cancel the project and the council may have to pay for the clean-up, so there's a high risk there. The majority of PGL sites have charges on them to Barclays Bank with a total value of 200 million, so there is no value in the assets. The supporting documentation to this meeting states that development within the Green Belt should not be permitted, according to paragraph 89 of the MPPF 2012, for this application unless very special circumstances exist. Therefore, this development should not take place. If planning consent is obtained, the maintenance of Cricket Close should be made mandatory, not advisory. If planning consent goes ahead, the residents should be informed when new PGL activities are planned, because they have an impact on the residents. Before new lighting is installed, residents should also be advised. Surrey County Council permit scheme to change road layout, has this been granted? If not, the work for the changes in the junction of Cricket Close and Tilford Road can't take place. Construction management plan needs to be approved prior to work starting. The residents would like to see this. The residents would want an assurance that no public footpaths will be closed during and after construction starts. From the plans, there are indications that footpaths will be closed. The noise management plan, there's been several complaints this year about noise from PGL late at night. The residents would like to see the noise management plan. No one in the vicinity of Marchants Hill wants this development to take place. PGL as a solid company is in doubt, looking for a new owner and in higher charges on assets. Risk to Waverley Council in PGL fell. Running costs to Waverley Council are estimated to be over 50k to date. PGL expansion means higher pollution levels and higher noise levels, plus increased traffic accident risks. Building in the green belt and industrial scale should not be permitted. There we go. That's my last statement. Thank you.
Thank you very much indeed, sir. I'd call on Kath, who's a supporter of the scheme.
Thank you for the opportunity of addressing you this evening on behalf of PGL. I'm their planning consultant. In considering this application in January of 2018, your committee resolved to grant permission subject to the signing of a Section 106, as outlined in tonight's committee report. Since that resolution, there have been no material changes in the planning circumstances which should alter your committee's decision. And we would request, therefore, that you grant additional time in which to sign up to the Section 106, which we understand is very close to being available for signature. As you are aware, PGL worked extensively on resolving the previous technical objections to the proposals and consulted widely with local people to develop the proposals which were ultimately considered acceptable by yourselves in January. Consequently, the proposals deliver a range of other improvements beyond the primary educational objective of my client, which are aimed at enabling more children to benefit from the outdoor experience which PGL offers. Notably, PGL's application involved a full review of the highway situation and its operation, and the resultant TA has been the subject of a Stage 2 safety audit, which was passed by the County Council. Additional information in relation to drainage, noise and visual impact was provided to allay concerns and address comments received during that application. No objections from the statutory consultees on any of these issues were sustained. A formal public consultation alongside individual meetings with those who could not attend was also undertaken by my client to understand the concerns of local people. The outcome of this work contributed to the improvements to the scheme, which was presented to you in January. Notably, none of the improvements to the access which would be delivered without these proposals, and the overall package of benefits represents an additional material consideration in favour of the proposals. In addition to the highway improvements recommended through our technical transport work, the following improvements are direct responses to the consultation comments received by from local residents, and that includes the amendment to Cricket Lane footway, the widening of the PGL access, the additional signage proposed on Tilford Road, the advanced signage, and a financial contribution towards a vehicle-activated sign to improve people's speed in the area. These measures therefore go beyond what the Highway Authority required to make the proposals acceptable in all highway terms. The application site has been in its current use for over 80 years, and notwithstanding its location in the Greenbelt, it provides appropriate facilities for outdoor sport and recreation and represents a developed site within your Greenbelt. Both of these circumstances mean that development as proposed can be considered appropriate development. Notwithstanding this, the proposal also delivers a range of other benefits as detailed in our submission, which would also outweigh any perceived harm. In conclusion, the PGL site makes a positive contribution to the local economy and the management of the site and the wider area. The application proposals will enhance this role, delivering improvements to an important learning facility, securing wider landscape and ecological benefits, and increasing the positive impact on the local economy and as a local employer. As part of the application, PGL has sought to engage positively with its neighbours and will continue to encourage this dialogue in the future. Therefore, given that there have been no material changes in the circumstances surrounding the case, I would respectfully request that you resolve to grant us additional time to complete the Section 106. Thank you for your time this evening.
Thank you. Members, it's our turn to make a few comments on debate this matter. I'll start off, if I may, as the local member. And I'm sure the officers will either agree with my comments or correct them should I stray. First of all, Cricket Close is a private road. It's nothing to do with Surrey Highways. We have got an informative in there, which is, I believe, the best that we can do. Hopefully they will resurface the whole road, particularly the one up to the House of Bethany, the former nuns' home. But Hindhead playing fields do use the road, but it would be nice to think that the heavy coaches that are continually trundling up and down, that PGL will take that on board and do something, not just to maintain it, but to improve the road surface. New lighting I know nothing about at all. I haven't seen any reference to that. Preconditions on highways and everything else are just that, preconditions. They can't do any building till the preconditions are complied with. No public footpaths will be closed, none at all. Noise is a problem that people have quoted. Environmental health will be very interested in making sure that the noise level is maintained or controlled in every way. It's a problem that hopefully just doesn't exist. The economic situation, the village does benefit to a small degree, not massive, but they do. The staff in particular are forever walking out the village using one of the outlets that I can think of. There is employment, not a great number of people, but some people are employed from the immediate area. So I understand the objections from the local people. It's our duty to make sure that noise and everything else like pollution is controlled. That's our duty. And I would just ask Louise now just to confirm my thoughts on lighting and preconditions and public footpaths. Louise, if you would be so kind.
Yes, I agree with everything you say. I would just add that lighting is controlled by condition 14, which states that no lighting shall be installed on site prior to the submission of a lighting scheme, and that any lighting should be carried out in accordance with those details. Thank you.
Thank you. But we are not here to debate the initial application. We are here really to take the recommendation B, which was to refuse the application should the legal document not be signed. The legal document wasn't signed because Chelsea and Kensington didn't get their act together. Their lawyers were a little bit slow, and that's the only change that I can see in this application, and therefore planning law dictates where we go with this. I don't know if Lewis Jones wishes to make any comment on the timescale. Lewis?
Nothing more than just to clarify why we thought 3 months was appropriate as opposed to 1. It's as I understand, close to being ready for signing, but nevertheless, it seems sensible to have a little more extra time just in case other parties such as Surrey County Council or Royal Borough of Kensington and Chelsea, have any issues with signing quickly. So really, it's just a safeguard, really, to ensure that we're not back here again, and due to another delay on someone else's part. So. Thank you, Chairman.
Thank you, Lewis. Members. Councillor Adams.
Well, yes, I mean, I just query that really because, I mean, they've had 8 months to get this S106 sorted out. Obviously, there's been a few changes, so they haven't done. But I really would have thought that there should be significant pressure on them to get it done. I'm not sure that 3 months is not too long. Maybe 6 weeks then, if rather than 1 month. But I mean, we want this thing to get going, don't we? So let's put pressure on them to get it signed up and ready to go.
Louise?
I completely agree with you, Councillor Adams. What I would recommend is leaving it at 3 months, but we will put pressure on them to sign it ASAP. The committee made a clear decision back in January that this was suitable for approval. We want to get this decision issued, so we will continue to put pressure on the signatories to get it signed as quickly as possible so that we can release that decision. But my advice to you would be leave it at 3 months just in case, so that, as Lewis says, we're not, back here in a couple of months' time. But I can assure you that both the legal team and the officers will be pushing to get that signed, hopefully within a month. Thank you.
Members, if there's nothing further to add, may I move to the recommendation? There are 2. Recommendation A, that subject to the completion of Section 106 agreement to secure highways works and contributions, including the provision of 2 speed signs, conditions and informatives, permission be granted. Those in favour, please show.
That's unanimous.
Thank you. Recommendation B, that in the event of a Section 106 agreement is not complete within 3 months of the date of the resolution to grant planning permission be refused. Those in favour of B, please show.
That's unanimous.
Thank you very much indeed. There are no legal comments to be made, I don't think. There's no reason to exclude the press and public, so that completes our meeting. Thank you.